Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Supposed to have Alex Ooley joining me. Mike Piwowarski originally was going to join, but he had things that came up. He couldn't make it. Alex Ooley said he'd step in, and he's having connection issues. If I see him join, I will bring in, as soon as I see him, I'll bring him in, and we'll get him on the air as well. It would be really useful if I could have him on, because you've got a couple of legal issues to tackle today, but it is what it is. So, got a lot of stuff going on. Before we get started with the news, as usual, I'm going to ask you if you are watching on either the YouTube or Facebook page for Polite Society Podcast, or really, if you're watching on a Facebook group for the Polite Society Podcast, you can comment on those videos. If you're catching us anywhere else, on OpsLens, on Rumble, on Getter, anywhere else you're catching us, go ahead and go to Twitter, tweet with the hashtag #TheBullet. We'll get those comments as well, and we'll get them on the air, and we'll discuss them. And again, today, since I appear to be solo, those comments will really help me keep things moving along. So, already getting some check-ins coming in from YouTube, and thank you for that. Let's go ahead and we'll get started right now with the news of the day. First one I've got off ab7newyork.com. Supreme Court on Wednesday allowed a New York gun law that places restrictions on carrying a concealed firearm to remain in effect while the challenges play out. In a brief order, the justices rebuffed an emergency request from challengers to the law who say it violates their constitutional right to keep and bear arms. They asked the justices to lift a federal appeals court order that froze a district court decision that invalidated key provisions. The justices declined to do so. Justice Samuel Alito wrote, joined by Justice Clarence Thomas, to say they agreed with their colleagues, but stressed they were not ruling on the merits of the law, but simply declining to intervene in the dispute at this juncture. The case is currently before the Second Circuit Court of Appeals. I'm going to get one quote in here from Alito. I understand the court's denial today to reflect respect for the Second Circuit's procedures in managing its own docket, rather than expressing any view in the merits of the case. He also wrote, he urged the lower court to expedite the appeal. What I see in this is, what they're saying, what Alito and Thomas are saying is, look, let the wheels of justice grind. Let this happen. The Second Circuit currently has the case, and they're working through it. All Alito and Thomas are saying is, we're not going to jump in yet. Give it time. Let the Second Circuit do its thing. But then they also wrote to the Second Circuit, look, make this happen quickly if you can. And I see. Okay, let me bring in, joining me right now, Alex Ooley of the Ooley Law Offices in Indiana. Alex, don't know if you heard, because I know you were just trying to join in and we had some connection issues, but the first story is that the Supreme Court declined to jump ahead and take the New York case, the case against the New York Concealed Carry Improvement Act right away. Basically, what Alito and Thomas said was, look, let the Second Amendment rule, then we'll see what happens, or the Second Circuit rule, then we'll see what happens, and told the Second Circuit, expedite this. Were you able to look at the story? Have I got that right?
Yeah, I took a look at the story, and I think, thankfully, there's a little bit of good news in this defeat. Like you said, the Supreme Court asked the Second Circuit to expedite the case. But the court also used some language in there that I think we can read into a little bit, maybe to read the tea leaves somewhat.
Oops. Sorry.
If you look at the Supreme Court order, and just, I guess, to provide a little bit of background, and I'm sorry if I'm repeating something you've already said, Paul, but for listeners, remember this case stems from a ruling by Judge Glenn Sutterby from a federal district court in New York in response to the so-called Concealed Carry Improvement Act, which had this good moral character requirement. It also identified all these sensitive places where firearms could not be carried, which we commented in past shows that it would have been a lot easier to identify places that people could carry rather than all the places that they identified as not, or off limits rather. So Judge Sutterby issued a preliminary injunction and a pretty lengthy opinion in the Antonyuk case in the district court, and basically issued that preliminary injunction because the Second Amendment plaintiffs have a good chance of winning on the merits once the case is fully litigated. Well, the Second Circuit issued a stay on Judge Sutterby's preliminary injunction. So New York law was enjoined by Judge Sutterby. That injunction was stayed by the Second Circuit, and then the Supreme Court considered whether or not to terminate the stay, essentially. And so that's what we got from the Supreme Court. But in their order, as you said, they asked the Second Circuit to expedite the case, but they also said the district court, so this is referring back to Judge Sutterby's opinion, in a thorough opinion that the applicants were likely to succeed on a number of their claims, issued a preliminary injunction. So the Supreme Court has apparently read Judge Sutterby's opinion, and they say it's a thorough opinion. Whereas with respect to the Second Circuit's stay, they say it did not provide any explanation for its ruling. So it's sort of an endorsement of some sort of Judge Sutterby's opinion, and sort of a slap on the hand to the Second Circuit, saying they've issued this stay with no explanation whatsoever. So I think that's a good sign, and I think the Second Amendment will ultimately prevail in this case.
I certainly hope that is the case. Let me ask this, and let's be clear that you are an attorney, but you are not a Supreme Court attorney. So, but how much weight does the request to expedite of the Second Circuit from the Supreme Court, how much weight does that carry? Will they now have to really expedite it, or?
I think so, because as part of the court's order, and this is in some extra comments from Justice Alito and Justice Thomas, they say applicants should not be deterred by today's order from again seeking relief if the Second Circuit does not, within a reasonable time, provide an explanation for its stay order or expedite consideration of the appeal. So what they're saying is, hey, if the Second Circuit doesn't provide relief, doesn't expedite this appeal, or explain why they granted the stay, come ask us again, and we may handle it differently next time.
Yeah, this is really kind of hopeful to me, although it didn't go the way we wanted it to go. It is hopeful to me in that it looks like, especially now that you've explained it as well as you have, it looks to me like they're saying we really did mean what we said, and we want to continue looking into this. So we'll have to wait and see. With a lot of things with courts, you have to wait and see. Excuse me. with a lot of, got it. With a lot of things in the courts, you have to wait and see, but I don't think we're looking at an extremely long period of time of wait and see. I would guess less than a year.
Yeah, I agree. I think, and people are always surprised at how long cases take in court. But this is a relatively young case. I believe Judge Sotheby's opinion was issued in November, and so this has made its way to the Supreme Court through the Second Circuit and to the Supreme Court relatively quickly. So the litigation in the Second Circuit, I wouldn't anticipate would take very long and could reach the Supreme Court relatively soon, at least as far as court cases go. So this is a relatively new case. And remember, this Concealed Carry Improvement Act was implemented in New York just days after the Bruin decision. I think it was maybe 8 days. I think certainly less than 2 weeks after the Bruin decision. So certainly we don't want people's rights to be violated at all, but this is relatively swift movement for a court case.
Well, and the other thing to keep in mind, I think, is that this is not a we're going to put it away forever. It's going to come back. I honestly think that this is going to New Jersey has a nearly identical law. Actually goes worse in a couple ways. I've got a story up later in the show where Maryland's trying to do something extremely similar. If we get this all coming through this year, it's going to knock down a lot of bad state laws.
Yes, I agree. I think it will.
All right, next story I've got that I found today was Florida officials have proposed a ban on state tracking firearm and ammunition purchases, arguing, doggone it, sorry, arguing that tracking them violates the Second Amendment. State Agriculture Commissioner Wilton Simpson, State Senator Denny Burgess, and State Representative John Snyder, all of them Republicans, announced the proposed legislation on Tuesday. They said the legislation, which Simpson calls the Florida Arms and Ammo Act, will prohibit the state's financial institutions from collecting data on firearm and ammunition purchases. I guess my big question here is, this is a Florida law. What happens to a New York bank, something like Bank of America, Wells Fargo, or a bank that may have branches but is not headquartered in Florida? Will they be affected? Yeah,
so I think even though, and I don't know where Chase Bank is headquartered, I think it's New York City. Even if Chase Bank is doing business in Florida, they still have to comply with Florida law, even though they're a New York business, or at least headquartered in New York. So they would need to comply with this law in Florida, even as an out-of-state bank.
Very cool. That I certainly hope that and I would if you are a state legislator in any of the other 49 states, especially the ones that like freedom, take a look at this law and let's get it spread as far and wide as we can. That's a great idea. If we need to stop the discrimination against firearms owners. So
and just to sort of couch my comments there, Paul, I haven't read this exact legislation. I've only read this article. So I don't know if this is meant to. It says, the article says that Florida officials have proposed a ban on the state tracking firearm and ammunition purchases. So it is possible that this is only effective with respect to Florida banks. So that would mean that Chase wouldn't have to comply. So if it's a bank that's chartered, so even if it's a bank that's chartered in Florida, that may be the only application here. But it sort of depends on how the legislation is written.
Yeah.
It's a little ambiguous from the article. So if the legislation says state chartered banks, then that would make a significant difference. So it would need to look up the exact wording of the legislation.
Going back to the article again, the one that gets me, they said the legislation, which Simpson called the Florida Arms and Ammo Act, will prohibit the state's financial institution from collecting data on firearm and ammunition purchases. That's where I kind of think I'm with you a little bit there, Alex. I think that it may be Florida chartered banks, which there are a bunch of, but some of the major banks in the United States are headquartered in New York City and elsewhere.
But either way, I think this is we've talked about, Visa and MasterCard and some of these other credit card companies who process transactions and the way they categorize purchases, and how there's been this push to track firearms purchases made with credit cards to identify suspicious purchases. And I think these are clearly efforts that will have no effect and will only serve to deny people who own firearms of a right to privacy. And it will be used in a way that abuses the rights of the people who exercise their right to keep and bear arms. So I think this sort of legislation is a good step in the right direction without knowing exactly the language of the legislation. But I think it's good that there are states making a movement toward protecting the rights of people who care about the right to keep and bear arms.
Well, and thinking about it, South Dakota, for many years, because of our banking laws, we had, and we still have, a Citibank where their credit card operations are based right here in Sioux Falls, South Dakota. I know that there are other banks that are headquartered in the other state that I see a lot is Delaware, because they have favorable banking laws. I'm going to have to see if I can't reach out to my local state legislators and see if maybe we can get something like this here, because if we can get the more places where there are banks with headquarters we can get this law enacted in, the better off it is for all gun owners, period.
Yeah.
Let's see here. This next story is off CentralIllinoisProud.com. At least 30 county sheriffs are refusing to enforce the newly passed assault weapons ban because they contend it violates the Second Amendment. Protect Illinois Act bans the sale of all assault weapons and magazines in the state. It also requires owners to register existing guns, among other provisions. Governor Pritzker signed the bill into law Tuesday night. LaSalle County Sheriff Adam Dees, Fulton County Sheriff John Webb, Knox County Sheriff Jack Harlan, and Woodford County Sheriff Matt Smith released identical statements deeming the law unconstitutional and say they will not enforce it. Well, the part they're not going to enforce is the mandatory registration within 300 days of all assault weapons in the state. I don't think there's anything they can do about you can now no longer sell these in the state. I don't think there's anything the sheriffs can do there. But at least what we're getting from these sheriffs is, look, Chicago is Chicago. We're not abiding by what Chicago says.
Yeah, I agree with your assessment there. I don't think it affects. I don't think they can have any impact on whether or not federally licensed firearms dealers can sell those items in Illinois. But this sort of harkens back to an issue, the whole sanctuary movement that we talked about. I think it was in early 2020 in Virginia. There was a big sanctuary movement, and there were a lot of sheriffs in Virginia. I think in 91 of 90 some odd counties in Virginia who announced that they were part of the constitutional sheriff's movement and wouldn't enforce what they considered to be unconstitutional federal gun control. And so I'm happy to see this from Illinois sheriffs. It is somewhat symbolic in nature. They can't change the law, but they are sort of the last line of defense in terms of law enforcement for people's Second Amendment rights, and other rights for that matter.
If the sheriffs will not enforce it, then the state police will have to, or possibly a city police force will have to. But if sheriffs say that, look, we're not going to enforce this, that takes a whole lot of teeth out of the state's bite.
Yes, exactly. And, with respect to federal law, obviously we know that state officials or county sheriffs, they can't be commandeered to enforce federal law either, so they can't be compelled to enforce these laws. Now, federal officials often use the power of the purse to try to persuade state and local officials to go along with their edicts, but they can't. There's this doctrine called the anti-commandeering doctrine that says the federal government can't force state and local law enforcement to enforce their laws. And there simply aren't enough federal law enforcement officials to enforce all their laws without the help of state and local officials. Yeah,
there are only so many federal marshals. There are only so many FBI agents. And this is really closely related, so I'm going to go ahead and bring this in early. Before I do that, even before I do that, let me get this comment in here. 500 Magnum. 20 years from now, do you think we'll have national constitutional carry? Boy, that's a great question. 20 years is a long time. We've got a lot of fight between here and there. I'd say maybe a 50-50 shot, but I tend to be an optimist. What do you think, Alex?
Based on, there's some discussion in the Bruin decision, I think it was in Kavanaugh's concurring opinion, about the appropriateness of licensing. And there seemed to be sort of this endorsement of shall issue licensing regimes. So I don't know that we'll get national permitless carry or national, just based on the commentary in the Bruin decision. But I'm like you, Paul, it's hard to predict the future, and it's hard to say where that might go. I mean, we didn't know we'd be where we are now with the Bruin decision this year. Last year at this time, we were speculating about who would write it. We didn't even know that. They just had oral argument on the Bruin decision in November of, not last year, but of 2021.
Right.
So things have changed and evolved quite a bit just in the last year. So it's really hard to predict, but I would bet against national reciprocity or national concealed carry, just based on the commentary in the Bruin decision. It's not binding language in the Bruin decision. It's just what's considered dicta. But I think some of the justices would be reluctant to strike down states that have shall issue licensing.
I will say this though, that some of the same, and you used the term dicta. I think that is where we're also getting the common use from the Heller decision. Was an Antonin Scalia, came out of an Antonin Scalia opinion when he wrote for that you can't ban what's in common use. Although that was never a hard part of the decision, it's commonly used in arguments now, especially when it comes to the AR-15 and weapon systems of that type. the AR-15 being the single most popular rifle in America, it's hard to imagine that a state such as Illinois will get away with the blanket ban of them.
Yeah, and obviously dicta is persuasive for future courts and future court opinions. Obviously, the holding of Bruin is binding, but the court, as you saw, it overturned Roe versus Wade. So lots of things can happen. There can be lots of developments. So it's extremely hard to predict, but I would bet against national reciprocity or national permitless carry.
Yeah. Next story is another good story. We have comments asking if we know anything about Nebraska. Well, Nebraska getting permitless carry is still that there's a bill that's been introduced, but there's been very little motion on it, at least this early. The story I did find from 10th Amendment Center today. A bill introduced in the Nebraska legislature would take on federal gun control and end state and local law enforcement of many federal acts that infringe on the right to keep and bear arms within the Cornhusker state. Senator Steve Halloran introduced Legislative Bill 194 on January 9th, titled the Second Amendment Preservation Act. Basically, nutshelling the rest of the story, they are doing what a lot of states have done in recent years and saying, look, we're not going to allow state funds or state resources to be used to enforce unconstitutional laws. I'm surprised Nebraska doesn't have that, but yeah, I'm just as surprised they don't have permitless carry. So,
yeah, and I don't recall, but I think, it does say here, state or local agents guilty of violating the act would be subject to civil penalties up to $3,000 on the first offense and a Class 1 misdemeanor charge on a second offense. So this law has some teeth, it sounds like.
Yeah, and this is not a felony, but Class 1 misdemeanor is no joke for a second offense, and $3,000, that's a lot of money for me. Alex, you're a rich attorney. That would be $3,000 to be a lot for you.
That's right. A $3,000 fine is hefty.
So let's go ahead and now we're down by the bottom of the hour, but I want to get this last story in here. This one off of Bearing Arms, a Cam Edwards story. Looks like Maryland is now their legislature just convened. The very first bill filed in the Maryland State Legislature this year, ironically titled the Gun Safety Act of 2023, would create a number of new gun-free zones where firearms are banned. So many, in fact, that the right to carry would exist largely only in theory. And I'm gonna pull up that story because the list is huge. An inn, hotel, motel, or other establishment that provides lodging to transient guests, a restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or other facility principally engaged in selling food or alcoholic beverages for consumption on or off the premises. I didn't know there were any soda fountains left in the United States. A motion picture house, theater, concert hall, sports arena, stadium, or other place of exhibition or entertainment. And there is basically it makes the entire state of Maryland, with possibly the exception of inside your home, a sensitive area.
Yeah, this is a lot like the New York law, the Concealed Carry Improvement Act, that the list of prohibited places was longer than the list that it would take to identify the places that you could carry. So clearly, I think the article's right in its characterization that the right to keep and bear arms in Maryland is really just a name only. And
I remember when we very first got the Concealed Carry Improvement Act introduced in New York, I was on with Charlie Cook, and I didn't do to you what I did to him. I started reading every place, and I did. It was 7 minutes to get through it. Every place that is a sensitive area in New York, and I'd forgotten that I'd hit the button and I'd left Charlie solo on the screen. And so for 7 minutes, he was just sitting there looking at the camera, nodding every once in a while. And man, I feel bad that I did that to him, but looking back, it's kind of... Yeah.
I'm glad you learned from your experience with Charlie and didn't do the same thing to me.
Yeah, no, that I very much don't want to do that. But Krabby Turtle has a comment coming in here. Says, I'm behind the lines in Marylandistan. Well, good luck, Krabby Turtle. And let me take just a second here to plug membership in the Second Amendment Foundation. We are fighting all these laws. We're doing it can we stop them from becoming law? We can advocate for them not to become law, but once they become law, what we do is we sue their pants off. And what we need to do that is members. If you're not a member, please do go to saf.org/join. A lifetime membership is only $150, and it does help us get these lawsuits forward. So, again, please, if you're able, and if you can't do a lifetime, do a 1-year membership. It's $15, and it does help.
Yeah, the Second Amendment Foundation is doing great work at the state, local, and the federal level. So the fight's not over, as we've talked about on quite a few occasions in the past. Paul, Bruen was not the end-all, be-all, and there is lots of work left to be done in the courts to vindicate our rights based on the Bruen decision. So there's a lot of work left to be done. The Second Amendment Foundation is a great organization. If you've got a state-specific organization that can help at the state level, obviously I would encourage you to look into that and contribute and maybe even volunteer for them if they've got events going on. So definitely encourage you to get out there and advocate for your rights, because otherwise politicians will be anxious to take them away.
Well, and I don't think legally we're going to be done for probably the rest of my lifetime, because when we win in the New York case that's up now, when we win, and I'm confident we will, New York will do just what they did when Bruen came through. Okay, well, we're going to stop. We're going to do a law. We're going to stop just this much short of what got ruled unconstitutional. Then we'll have to take them back to court again.
Yeah. Yeah, the fight will never be over. There will always be people who are in power and want to have more control over our lives. So there will always be those battles to fight. And, freedom is lost a little bit at a time, and we need to fight back for it a little bit more at a time.
All right. Well, we are past the 30-minute mark. We do need to get out of here. Alex, do we have a podcast to promote yet, or is that still in the works?
I released the first episode last weekend of the Forge of Freedom podcast. You can find it on all your podcast streaming sources, as well as YouTube, Rumble, and Odyssey. I'll have another episode coming out this weekend. I'm planning to release an episode once a week, and we talk about firearms, but my passion's not just firearms. I think firearms are indispensable to a free society, but I'm more generally passionate about freedom, and we talk about lots of issues related to freedom and maintaining our freedom for our own life and for future generations. So check out that podcast, The Forge of Freedom.
Very cool. Now, Alex will be back tomorrow. Tomorrow is his regular day. He just, because I had Mike Piwowarski basically pull his shoot cord and bail on me, Alex decided to come in today to help out. He'll be back tomorrow. But Alex, thanks for stepping in today, man.
Oh, no problem. Great to be with you, Paul.
All right, folks, we're going to go ahead and shut it down for today. Please do come join me and Alex tomorrow, and don't forget to join us at noon on Saturday for the weekend wrap-up show. Thanks for watching, everybody. We'll see you